Glen, over to you.
All right, thanks, Glen. And I want to thank Glen for helping with all, and Bob and Liz for organizing today's session. And in particular, thank Sheila and Rohan for their agreeing to participate in this. Not only are they both experienced and regular investigators, they're also now volunteering their time to talk about this. As Glen said, we sort of had two audiences in mind for this. One is for members of the Discipline Committee. This is an opportunity to hear about other ways that people approach investigations, possibly get some different ideas. I think even in our pre-discussion that Sheila, Rohan, and I had, there was some interesting different perspectives on things, and I'm sure we'll hear more about that, and we'll look forward to hearing from people who may have different perspectives as well. We also thought that this would be good for members who are not part of the Discipline Committee, but as I always say, when you reach a point where there is a complaint against you, not if, but when, it is useful to understand what's going to happen next and what the actual process will be. So that's the second part of this that we're going to be going through. We're going to start off, I'll just do a quick, little bit more introduction, and then we're going to sort of have four key parts that we're going to focus on. Very quickly, I'm going to speak to getting to the investigation stage and starting the investigation process. And then we're going to have a bit of a discussion about the role of the investigator, and then a discussion about the investigation process. Essentially, once you're the investigator, right from receiving the complaint to writing the report, talking about some of those key steps. And then, as Glen noted, if you have questions, please put those into the chat function, and we can, I would encourage you to do that as we go along, particularly if it's relevant to the conversation that we're having. For those who don't know, Sheila MacPherson is in private practice here in Yellowknife at Lawson Lundell, an experienced investigator for discipline matters both here and also in Nunavut. And Rohan Brown is legal counsel with the Government of the Northwest Territories Department of Justice, and again, another experienced investigator who has done a number of investigations for the Discipline Committee. Myself, Glen Rutland, I am chair of the Discipline Committee, which means I don't actually do the investigations myself, but I do read every investigation report that comes back and makes conclusions and decisions based on those investigation reports. So that's the perspective where I'll be coming at this. Also, when I previously was in private practice, I conducted a number of investigations around workplace investigations. So quickly, to get through the first couple steps of the process and into the more substantive discussion, how do we get to the investigation stage? So first, what happens is a complaint comes to the Law Society, and a complaint generally comes to the Law Society in about three different ways. So one, it can come from a third party. It can be generated by the Law Society itself, or by myself as chair of discipline, or it can be through a self-report. It's come from third parties. So these are usually complaints where someone is complaining about their own lawyer. They're complaining about the actions or conduct of another lawyer involved in a matter. And on occasion, it's also complaints from one lawyer about the conduct of another. Generally, when lawyers report themselves to the Law Society, it's because something may have occurred that might constitute unprofessional conduct. And for example, if a lawyer is charged with a criminal offense. Where a complaint may be initiated by the Law Society is whether someone is failing to respond, they're not maintaining their status, or else something comes to my attention as chair of discipline where I believe that there may be unprofessional conduct or conduct on becoming a barrister and solicitor. So once the complaint is received, I do an initial assessment. Essentially, it's a fairly low standard to get to an investigation. A complaint can be dismissed if essentially I'm satisfied that even if everything they say is true, it would not amount to unprofessional conduct, conduct unbecoming, or professional misconduct. That's a fairly low standard, so I would say more often than not, a matter is going to be referred on to investigation. And then as chair, the next step is identifying an investigator. So how we do that is we look at the list of members from the discipline committee. Ideally, there's a number of considerations. Depending upon the nature of the complaint, if it's practice related, we would like to try to find someone with some expertise or some experience working in that area. Someone who doesn't have any conflicts with the file. Someone who we just haven't asked to do an investigation the month before. We do try to spread it out amongst all the members so that we're not putting too many obligations on you. So those are sort of the key factors that we go into in selecting an investigator. So then I'll reach out, find an investigator, and then the investigation process starts. At that stage, the Law Society becomes, and primarily Glen at the Law Society, becomes the central point of contact. So letters will go out to the complainant, to the responding lawyer, saying a complaint has been received, it's been accepted, and the matter is being investigated. They'll be told who the investigator is and that the investigator will be in touch with them. And the Law Society will do that. And then after that, the role then goes on to the investigator to receive those materials, review, assess, and ultimately report back. And we'll talk about that little report later. The first question, I guess, that I would pose to Sheila and Rohan is the role of the investigator is to determine whether or not there's a reasonable prospect of conviction. So it's not a question of finding guilt or innocence. And I guess sort of how do you approach that as you start going through the investigation process? And maybe I'll start with Sheila.
Thanks, Glenn. That's a great question. It can be a bit of a challenge depending on the factual situation to determine how to apply the standard. We've developed the standard that there has to be a reasonable prospect of conviction for a few reasons. Firstly, the standard of having a prima facie case, just a bare case, is a fairly low standard. And there's not a great deal of value to the public interest in sending on matters to a hearing where somebody has just met a very, very low standard. At the same time, what we don't want to do is make the threshold so high that we're predetermining the issue at this very, very low, at this very early stage. So the biggest thing is, is there a reasonable prospect of conviction? How do you assess that? You've got to look at the facts. You have to look at the facts, determine whether any of the facts are contentious. Surprisingly, lots of times they are not contentious. It's just the perspective of the individuals involved that may differ, but the facts themselves may not, in fact, be in dispute at all. And then the next issue is, from my perspective, is trying to sort through and figure out, is the conduct that's complained of something that is improper conduct, is unprofessional conduct under the code of conduct? Most of the time it is, and it hits you over the head. There's simply no doubt that the conduct itself is improper conduct. For example, a really frequent complaint of clients, we all know this, is failure to respond in a timely manner to clients. That's a huge complaint, and it's interesting. Lawyers or the public and your clients will forgive many things, but what they often won't forgive is not getting back to them. So failure to respond in a timely manner, we know, is improper conduct. But there can be other things that a client may complain of, or a member of the public may complain of, that you sort of go, is this something that falls within the realm of the Law Society complaint process? And sometimes that can be where the lawyer is doing something in their capacity as a private citizen, for example. So I try to go through and take a look at what the facts are, determine, is there any controversy about those facts? And what is the nature of the conduct being complained of? And that's sort of the initial approach that I take to the complaint at the very outset, Glenn. So it's a bit higher than just a bare case, a prima facie case, but it is nowhere near as high as finding that the conduct occurred or not occurred.
Okay. Rohan, how about your approach towards the issue of reasonable prospect of conviction, but not finding guilt or innocence?
So I should preface my remarks by mentioning that I've carried out, I think, 8 investigations at this point, and I have yet to find that there's a reasonable prospect of conviction. So another important initial point I have to make is that what I found is very often the complaint that is sent to me is not at all well articulated, and in many cases it's even unclear what the nature of the specific complaint is. And so I find generally that when I initially interview the complainant, I'm also carrying out an unofficial role of discerning what the complaint or complaints are. And that's not entirely ideal, because in doing so, I'm taking off my investigator hat and almost kind of putting on a sort of quasi counsel to the complainant hat. But the only ways to avoid that would be to have that process carried out as part of the intake process, or to actually fund or otherwise provide for counsel to the complainant. And I can understand why neither of those steps are taken. So with those initial remarks out of the way, I don't have all that much to add to what Sheila said. I think Sheila made a lot of excellent and important points in her remarks. What I try to bear in mind is that I'm not making the final finding if there is a referral, and so I don't need to try to analyze all the nuances that might exist in any precedents that exists with decisions of other law societies or whatnot. What I'm looking for is whether there's a decision that is analogous in some kind of way that would apply in the scenario at hand, or if there's any kind of ambiguity about that. Another important point I bear in mind when I'm carrying out my investigations is that the standard isn't perfection or good conduct on the part of the counsel in every case. The standard is what's set out in the code, and in many cases that's a pretty low standard. And there's conduct that a lawyer can engage in that isn't what we regard as good practice or otherwise good conduct, but it's not a violation of the code.
And I think that's an important point, and our act sort of acknowledges that, where one of the options that I have upon receiving a report is that if there is a report that says there is not a reasonable prospect of conviction, but there are some, maybe some bad practice that took place. It doesn't amount to unprofessional conduct, but maybe is sort of bad practice, or there are ways a lawyer could handle a situation differently. Our legislation allows for me to sort of say, okay, and effectively it's almost like a fireside chat. So what I can do is I can ask one of the members of the discipline committee who may have some experience in that area to have a chat with the member and discuss, here are some ways that you can handle these practice issues differently to avoid getting back into a complaint position. So certainly that's recognized. And I would just say, before everyone starts hoping that Rohan is their investigator when there is a complaint, I would say on average, generally we receive about 10 complaints a year, and usually maybe one ever goes beyond usually only one meets the reasonable prospect of conviction. So we'll see what happens in the next 1 or 2 investigations that Rohan gets, but
yeah. Glenn, I can tell you I've sent plenty on. Definitely not half of the ones I've done, but there are times when you just know it needs to be sorted out at a different level because the conduct was sufficiently serious. So it's always a hard decision to make. But if we're going to discipline ourselves in the public interest, it's one we must make.
The other thing that I just wanted to add, just that members are aware of, particularly for members of the discipline committee, is that you are indemnified if you are acting in good faith as an investigator. So there is protection in the Legal Profession Act that does protect you. I know that question has come up previously, particularly where we're maybe dealing with a member who's not insured, who's doing the investigation. But there is as long as you're acting in good faith, there is protection from liability as you're doing this. Sheila, I'm just wondering if you can touch a little bit more on this issue of finding the question of whether or not there's a reasonable prospect of conviction versus not getting caught up with whether the outcome may fit the offense, say.
That's a tough one. That's a really tough one. And it's something that typically comes as I begin my investigation, end up talking to various witnesses or hear from various individuals, almost always in writing. And I know we'll touch upon the investigation process. And every single complaint, quite frankly, I found is a little bit different and has to be handled a little bit differently. You can have, and I think I've had just a really broad variety of comments and complaints. So, for example, it seems to me that often, rarely the facts are in dispute. Characterization of the facts is frequently in dispute, but not the actual facts themselves. So when you look at the facts, you have to look at the overall context of those facts to determine, all right, in the bigger picture here, is it likely that this is going to result in a sanction or in a finding of improper conduct? No, probable, but definitely not that there's a chance. And you need to look at the big picture. For example, failure to respond to clients. It can be very, very telling if you have a lengthy history with a client. You have a history of sort of competent, professional delivery of services, and you have one isolated event that you're assessing in the whole context of that client-lawyer relationship, socio-client relationship. Also relevant is there a reasonable explanation? The whole issue of reasonable prospect of conviction is tough, and the role of defenses is a tough one because a defense can go actually to mitigate or perhaps go more to sanction than to whether there's a prospect of conviction. That's the difficult part I have. But where, for example, hypothetically, you have an extremely long professional competent solicitor-client relationship, all of a sudden you are out of town by virtue of an unexpected emergency. The client complains that you didn't get back to them that 1 week you were out of town, or you had thought you had made arrangements to have that client covered, those arrangements were, from an objective perspective, reasonable, not speculative, but very much client focused, and yet they fell through. That defense actually can go to, there really isn't a likelihood that if this went to investigation, that this otherwise professional, competent lawyer is going to have a finding made against them. And so that's sort of the analysis that I go through, which is, it's got to be something more than a mere chance of a conviction. There's got to be something there to ground it. And that's what I go through in my mind. And oddly enough, while I've had a wide variety over the years of complaints involving all sorts of human behavior, very rarely, quite frankly, do I have the facts in dispute, and that sure has helped in that analysis about whether there's a reasonable prospect of conviction.
Rohan, any thoughts on your end in terms of trying not to let that final outcome or final process, affect as you're going through the investigation?
I've been pretty fortunate in that I haven't encountered a situation yet where I've felt like I'm struggling to make the determination of whether or not that threshold is reached. I've probably, of the 8 investigations, 2 where there's been really any issue of credibility on a pivotal matter. And in those cases, it was not too difficult to make the determination on credibility either. So I'm fortunate in that respect, but I definitely think we need to keep out of our minds any thoughts about what the penalty might be, or whether the person seems to generally do a good job, or they were trying to do the right thing. We have to apply a generally objective standard.
Okay. And if I just might add as well, Glenn, there are sometimes when, again, they're fairly rare, but there's sometimes when the outcome is simply unknown as to whether the conduct complained of is contrary to the code. And I'm thinking about one example, a good example of that type of case, where many years ago there was a well-established practice for dealing with criminal clients and having conflicts to screen criminal clients. But as part of that, a law firm's conflict process did not including complainants who might be adverse in interest to former clients. And that whole issue went to a discipline hearing because the issue before the decision maker was, what is the standard? How do we apply our conflict of interest rules and our ethical obligations to avoid conflict of interest in a particular fact situation in the northern context where we have circuit court, and it's not always easy to be running conflict checks when you come across complainants who you didn't realize you might have had a professional relationship before. So that entire issue went to a hearing and a determination that helped guide future lawyers in terms of what processes they that process sort of helps educate us all as lawyers about what our obligations are. So it's not always a bad unclear, and leave it for the investigation hearing itself in order to flesh out those bigger issues, which quite frankly need to be fleshed out.
Great. So we'll sort of move on to the start of the investigation process, which is generally receiving the complaint and then receiving the response from the lawyer. And I think I understand from Glenn that there may be a question about that.
Thanks, Glenn. It's an unrelated but kind of related question. The question that we got from one of the participants is, how do you recommend, and how do the panelists recommend, that a lawyer deal with a situation where they have a lawyer on the other side of a file, or perhaps the other side of a number of files, who is not responding to requests. And this is not a one-of situation, but rather it appears to be an ongoing situation involving a number of different sets of correspondence and a number of different files. How do you and the panelists suggest that that the lawyer deal with that?
Okay. Well, I'll jump in first. And one of the things that you can do is actually have a discussion with the Law Society about that. One of the things, and sort of taking it back out of that immediate context, but one of the things that does happen is a lot of complaints start by a phone call to the Law Society. And there is actually some pre-screening and pre-resolution that can happen by the Law Society staff. So for example, if someone calls in and is like, my lawyer is not responding to me, I've done this, I want to file a complaint, you know, often a phone call from the Law Society saying, this client is calling, you haven't responded, you know, you need to respond, otherwise you're going to be looking at a complaint, is enough to have the lawyer respond. Because ultimately, that's what the client or the person who's making the complaint is looking for. The discipline process itself is likely not going to give people the remedy that they want. While it may be a sanction against the lawyer, it's not going to get them, you know, if they didn't win in court, that's not going to be changed. So I think that's one of the things. And certainly, if you are having issues with a lawyer not responding, you may not be the only one. And if the Law Society is hearing about it from multiple people, then it's something that they can certainly raise as a complaint. I don't know, Rohan, whether you have anything else to add on that?
It's not part of the investigation process, but just some thoughts off the top of my head. Well, one is that when you send out reminders, if you've taken that initial step of contacting the Law Society and asking them to raise the issue with the member, you could send reminders and then copy someone from the Law Society on those emails. So that may add to the motivation for counsel on the other side to actually respond, because it should trigger in their mind that, whoa, I'm at risk of potential complaint here. If there continues not to be any response, though, then presumably at some point you have to make a decision of whether to pull the trigger or not on a complaint. And well, as Glenn mentioned, that's not going to necessarily get you a response from that member anytime soon, but it is at that point probably the only recourse you have available.
What you can't do and should never do is threaten a complaint as a way of getting the lawyer to respond to you. And that was probably one of the biggest things I remember learning as a young lawyer was that it's unprofessional conduct in itself to threaten a complaint. If you feel that a lawyer has violated the code of professional conduct, as a self-regulating profession, we have an obligation to deal with that, but not use our code as a tool to obtain a remedy that you want. So, you know, in an extreme case, there may be no option, quite frankly, but to file a complaint with the Law Society. That's part of the price and the responsibility that we have as a member of a regulating profession.
Yeah, I fully agree with Sheila.
Yeah,
on those points.
All right, Rohan, maybe you can tell us a little bit about your practice once you've received the complaint and then received the lawyer's response. What sort of process do you start following for your investigation?
So what I will do almost always is email the complainant and arrange for a phone interview. And that usually is necessary to, as I mentioned earlier, among other things, clarify what the specific complaint or complaints actually are. And once I've taken that step, what I'll usually do is if the nature of the complaint wasn't clear from the initial complaint, I will email the member or members involved and notify them of what the specific complaint actually is. And then in every case except for one of the investigations I've done, have arranged for a phone interview with the members involved. And I find that's important to clarify, well, first of all, what the response to the actual complaint is, and then also to provide the council with the opportunity to add to what they have provided in the initial response. It's also, I find, helpful if there appears to be any potential issue of credibility to have that discussion at an earlier stage. What I also find quite often is that after having carried out the initial interviews and then having carried out my initial legal research, quite often I'll realize there's one or more matters that I need to go back and ask more questions on. So typically that'll be to the complainant, but it can also be to the member involved or other individuals. I had one investigation where I didn't need to interview the members involved, and there was one other individual who I interviewed who was able to provide the responses on all the pivotal matters, and that was conclusive. You're on mute, Ben.
Oh man, first year on mute of 2021. Sheila, perhaps, I know you take a slightly different approach than Rohan does when you're putting together and sort of starting and rolling out that investigation process, and maybe if you want to talk a bit about that.
Sure. Yeah, unlike Rohan, I almost never conduct telephone interviews, except in the rarest of cases. I will almost always proceed in a much more formal fashion. I guess it's the cautious lawyer in me wanting to make sure that there is a written record of all the communication that I have with both the complainant and with the member involved. So when I get the initial complaint, like Rohan, there's often a lot of distilling that needs to be done. You really, you get a complaint and it's like, bleh. The poor complainant has just sort of poured out their soul to you, and sometimes it takes a little bit to sort through and figure out what they're really complaining about. If it's not immediately obvious, I will actually write back to the complainant asking them to elaborate on point A, B, or C. If it's not immediately obvious, but almost always my first step is to communicate in writing with the member, confirm the delivery date of their response, and I proceed from there in terms of then receiving their response, sometimes going back and forth with the complainant and with the member. It's quite rare, I think, for me to actually have a phone interview. I have had a few in-person interviews, never with a member. My correspondence with the member is almost always quite formal, but there are occasions where I do need to speak with the complainant. I had kids once on a discipline file, and I met with the children because obviously it would have been completely inappropriate for me to communicate in writing with them. They were barely teenagers, and so I met with the complainants and sort of teased out a bit what their concerns were. And on another occasion, I met with the complainant, and basically it was a case where the conduct alleged was simply a reality of being in a small community, and where there had been a concern expressed about social connections between the member's office employee and some other members in the larger community here in Yellowknife. And I mean, this happens all the time. So it was helpful to be able to sit down with the complainant and get a sense of their concern. But I would say that from my practice, that's the exception rather than the norm. And I almost always have quite a paper trail. And as somebody whose discipline decisions have been JR'd, the subject of judicial review, I think that has ended up serving me well. I had one of my decisions not to send on to an investigation judicially reviewed by the court. This may also be a good time, Glenn, to sort of chat about what happens if you have a complaint filed against you and you're responding. It's a very difficult experience for any lawyer, and I never, ever take it lightly, the emotional impact that this can have on the lawyer involved. Even the most professional and experienced lawyer can be thrown by having a complaint filed against them. Lawyers don't need to hire lawyers to respond to a complaint. It's, it's not part of the process. It doesn't need to be part of the process. But in my experience, there can be times when it might be valuable for a lawyer who is facing a complaint, if they have the ability to run the complaint or their response to the complaint by somebody who is either another colleague or a trusted confidant, that may also serve them well. Because there are times when I find, simply because we are in some respects not our own best advocates, there are times when I find it can be difficult to get at what the lawyer's position is because they're so thrown by the complaint. So that's just a little piece of advice. In some cases, you may want to say to someone, listen, I've had this complaint filed against me. Here's my response. Can you just give me some thoughts on the response and how I might better respond and make my point more effectively involved. But yeah, I think that's one thing we learned is I tend to feel a little bit more formal than Rohan. At the same time, I'm also really concerned about the timelines. And so I know that a more formal in writing approach can add to those timelines for actually getting the job done.
Yeah. And
so,
just before I throw back to Rohan, I would just note that on the timeline, so there are national standards, national discipline standards that the Federation of Law Societies of Canada have set and the Law Society has adopted and that we report on annually. I can say, I think for 2019, we were the only jurisdiction to meet all of the relevant standards that applied. We were the first to do that. And part of that is we didn't have a hearing that year, which made it a bit easier. But just in terms of investigations, normally is that we try to have the investigation completed within 90 days. So that is the time frame that we're giving you. And that's usually one of the questions I will ask you when I'm asking you if you are available for an investigation. So I'll say, these are the parties involved, this is what it's generally what it's about. And I'm looking for a report by, usually like 3 months out. Because if you have an incredibly packed calendar during that time period, I'd rather have you say no so that we can still get it done. Because one of the reasons we try to do it quickly is because there is this emotional weight that can go with having this complaint hanging over you. Rohan, any other comments about sort of managing that initial lawyer reaction as the investigator?
I think Sheila's remark about the spilling out of from the complainant is true in the vast majority of cases where it's someone who's not another lawyer who's made the complaint, and in some cases where it's counsel on the other side who they're complaining about, there's some bitterness involved in whatever has happened. in those cases, you have to put out of your mind any thought about, oh, well, this is almost certainly just a vexatious complaint, because, well, while that may be true in some cases, you can't go into the investigation with that kind of bias in your own mind. So I try to keep all my head clear of that and just carry out the investigation objectively.
Have either of you had challenges with getting a response from the lawyer or member who's being complained about? Have you had any challenges with that? I know at times extensions may be required, but has there been any particular, obviously not using specific examples, but have you faced the situation of a lawyer who's just not responding or engaging in the investigation?
No, I haven't, Glenn, and I'm always amazed actually at how seriously the lawyers that I'm involved with investigating have taken this process, and I've always respected their adherence to deadlines and reasonable deadlines. Every once in a while, somebody needs an extension, and that's completely fair. But no, it's to me it says a lot about the lawyers that we work with here in the north. That for the most part, my sense is that they're quite responsive. I don't know, Rohan, have you had any issues?
My experience has been the same as you, Sheila. I've always found that the member complained of has responded to any email I've sent very promptly, and then they've in every case been keen to arrange for the phone interview that I want to do sooner rather than later. What I've experienced quite typically from the member complained of is that they are very concerned that there's a sense often that they shouldn't even be having to go through this because there's just no basis for it, and I have to explain to them that, well, it's just unavoidable once a complaint is accepted that this process occurs, and it doesn't mean that there's necessarily any likelihood of the complaint being referred beyond the investigation process.
And it's important to note that for members, it can actually be a new complaint or discipline matter if you fail to respond to requests from an investigator. There's also the ability for if a member is refusing to respond or refusing to engage or refusing to produce relevant information, an investigator can apply to the court and have an order for that information to be produced. Obviously, we want to avoid getting to that point. And certainly if you feel like you are getting to that point, you should reach out to either myself as chair of the discipline committee, or if this is a matter that's being dealt with by one of the vice chairs, so whoever it was who may have brought you in as the investigator, it's important to reach out to them and have a conversation with them, because there's always the ability for us to get involved and just, say to the member, we're not weighing in on the merits of the complaint at all. Our only concern is about the process, and here are the repercussions of the process if you don't participate, or here's where we could end up, and that would hopefully be enough to move that situation along. But certainly I think cooperating with the investigator is the quickest and most efficient way of actually getting this matter resolved. Sheila and Rohan, you've both commented on that it's not often that there's issues of credibility, that quite often the facts are not in dispute. And I'm just wondering whether you can explore that a little bit more. One, how do you address credibility when it is in question? But generally, approaching this when the facts are relatively clear.
Sure. I think there can be times, and we see this a lot with client-driven complaints, And I'm not talking about the complaints that we so often see, which are delay and non-responsiveness. And those are the easiest complaints to avoid. But they're the ones that'll trip up most lawyers. But you can often have the client just have a real misunderstanding of the outcome of a matter and why a matter went the way it did. And they simply don't understand. It's a court matter. They think the lawyer didn't do a competent job. They think that's something the lawyer did, perhaps being friendly with opposing counsel, for example. One complaint that I dealt with many years ago was about the common use of the phrase, my friend, my learned friend. Well, my lawyer was friends with the Crown Counsel. That's not fair. That's why I got convicted. The facts in that case weren't in dispute, but the characterization of it very much is, and it can take explaining to a complainant that this is sometimes the way lawyers talk. And it doesn't mean that the lawyer isn't competent. So though, where the facts are not in dispute, sometimes it can be clear to arrive at, is this professional misconduct or is it not? But there can also be the gray area where failure to respond, for example, you've got one instance of failure to respond out of 20 that may not be conduct unbecoming. But if the client comes up with, here's a whole bunch of problems we've had on this file, that in itself can be problematic. So my experience has been that every case is a little bit different. Where the facts are pretty clear, you have to then look at the overall context to see, is there a reasonable prospect that there's going to be a conviction out of here? Where credibility is in dispute, in the few cases where I've had it in dispute, that's a very difficult thing to assess. To caution and sent it on, and not dismiss it that early stage. But where it's quite clear, then I consider I have an obligation to not waste the time and resources on an expensive hearing where it's evident that the witness is simply not credible.
All right, Rohan, any comments from you on that one?
It's a question where it's unfortunate that I can't go into the details of the investigations where there was any issue of credibility, but talking in vague terms, the one case that comes to mind was one in which the complainant had alleged that the counsel had failed to convey a lot of key information to him, but the credibility determination wasn't too difficult because there was email correspondence that while it didn't set out exactly what had been conveyed, made it pretty clear that the key information had been conveyed. If you have a situation where there really is an indication of some issue of credibility, then I agree with Sheila that it's necessary to refer it probably for a hearing.
Okay.
And in making that determination, though, I think it would be hard to do so without having spoken to both the complainant and the member on the phone, because it's only, I really think it's only when you talk to them in person you can start to get a sense of who may be more credible and really trying to scrutinize that to at least some extent.
And Rohan, I know you mentioned earlier, sort of when you get to the report writing process, you sometimes talk about legal research and stuff like as part of that process. I'm just wondering, how do you approach the use of other materials like precedent decisions or the code of conduct and things like that as you're working on your investigation report?
For me, it's an iterative process. After I first receive the complaint, I'll take a look at the applicable, what appear to be anyway, the applicable sections of the code. If after I've interviewed, if it appears that the complaint is different than what it initially seemed to be, then again, I'll go take a look. Usually we'll do some searching for precedents with decisions of other law societies, our law society, if there's any out there, and any court decisions at an early stage too. And then once I've carried out the initial interviews, the initial research, and then I'm turning my mind to thinking through matters carefully, I will usually end up having to go back and search for one or more precedents on specific points. And sometimes that can trigger for me the need to ask one or more additional questions to the complainant, a member, or someone else. So yeah, just to reiterate, it's a iterative process for me.
And maybe before I move on to Sheila, just if you can sort of talk about recognizing everyone has a different sort of writing process, but what your writing process is in terms of compiling the information, the evidence, and that kind of thing, and then approaching the writing of the report.
Oh, are you asking Rohan?
Rohan. Yeah, okay. Just if you could tell us a little bit about, just a little more detail about your writing process there, and then I'll move on to, I have both questions to Sheila.
Sure. So I generally like to have in my mind and or on paper a pretty solid outline of what is going to be in the decision before I start to put pen to paper. And what I find is that there's often ends up being really one pivotal sort of determination we made. Sometimes it's something factual, sometimes it's more of a legal nature, and it's only when I'm satisfied that that matter is fully resolved, if there's more than one, all those matters, that I feel comfortable to begin writing. Sometimes once I've started writing, I'll realize, oh, well, it would be helpful to carry out a bit more research on this issue, or just obtain full clarification on some fact that isn't pivotal, but I need to make sure it's set out accurately. So I come back sometimes to do additional work on such matters, but 75+% of the time, once I start putting pen to paper, I have everything I need to be able to write the full decision.
And Sheila, I know you probably approach the writing of reports differently based on what we've talked about. So I wonder if you can touch on that, and then also if you can touch on your use of the code, the annotated code, and precedent decisions.
Sure. I almost never know what my decision is when I start writing. We had the three of us had the benefit of chatting last week on this, and I find, for me, the very process of setting out the facts is something that helps me work through what's contentious, what's not contentious, is credibility an issue. So that's a big part for me of actually getting my thought process to the point where I'm able to weigh everything and arrive at a decision about where I'm going and where the gaps are. So almost immediately I'll start to write out what the facts are. If you're being asked to do an investigation, the Law Society will give you some really, really handy material including a template report. And I find that template report really valuable to use. It's very, very helpful. And I just start by plugging in what the facts are, and then the lawyer's response, going from there. And the analysis is the last part I do, but sometimes by that point I've sort of worked it all out in my mind, and that part ends up flowing a bit more. But I can, swear that when I usually start writing, I have no idea where I'm going to go on a report. And I also find that I end up, the very first source I usually go to is the code, and the annotated code, just simply to ground myself in what is the conduct complained of. Does this come within the purview of the code? Sometimes it's just blindingly obvious. Surprisingly, on other times it's not so obvious. You really have to wrap your brain around, is there an applicable section here, or is this something that's just outside of the scope of the code? So I find the annotated code helpful. Other discipline decisions are also really helpful. Unfortunately, we don't have a lot of investigation decisions that are out there, and I know we don't share them because it's such a small discipline committee. It would be very difficult to share investigation decisions without revealing the identity of the lawyers involved, where complaints are dismissed, and there's a privacy interest at play there. So that's a little bit unfortunate that we're not able to do that simply because of the small size of the jurisdiction. But I do find looking at discipline decisions from both the NWT and other jurisdictions helpful. And then every once in a while, I go further afield and I'll actually research some of the code provisions and see if they've ever come up in just general decisions out there, or there may be an interesting legal point that I'll have to research. I had to research a point some while ago on the impact of filling out in a certain way a federal form, and what were the consequences for not being accurate in how that form was filled out. It can't sort of be broader than that, or can't be clearer than that, but that required me to go on a little frolic about what this form meant in the bigger sort of picture. So every once in a while there is a bit more legal research, but the go-to is clearly the annotated code and other discipline decisions. And then hopefully by the time I've arrived at my analysis, I have a good idea. Where I'm going with that, but it's definitely for me a work in progress when I start out.
And I know Sheila was saying, it's unfortunate that we can't share the investigation reports and things like that. But one of the things that we do ask is that you do share a copy of your draft report.
Yes.
With the chair or vice chair of the discipline committee who's sort of managing that complaint. And so that members are aware, like, as the chair, when I receive one of those, I'm not looking at it from a point of view of, I want to have any sort of influence on the outcome or on the decision or that kind of thing. But, myself as chair and the vice chairs have the advantage and the experience of reading a number of these investigation reports, because we're going to see all the investigation reports that come through. So we've had the opportunity to see a lot. And what we're really looking for is, are there any gaps? Are there anything where we might just want to say, you know what, you might want to just fill in this area a little bit more or something like that, just to get to the point of, making sure that the report supports whatever conclusion it is that you reach. Like I said, our role isn't to influence that decision at all, but our role is just to make sure that that investigation report is sort of meeting a standard and keeping us going in terms of where we need to be if ultimately it gets to the point of being judicially reviewed or something like that. So that's where our role is, and that's the expertise that we can bring, is we're one of the few people who have seen all these investigation reports. So certainly that's something, if the chair or vice chair is coming back to you, with a few suggestions or something like that, it's really just coming from that place and not coming from okay, change your conclusion, right? Ultimately, if we disagree with your conclusion, we disagree with your conclusion, but we're not going to ask you to change that.
I have to say, Glenn, I find that useful and reassuring to have my report reviewed. I remember one time sending a report to one of your predecessors and just really needing that gut check because I was sending it on saying, am I out to lunch in this? And it's a helpful process to have that second set of eyes. Plus they catch typos, which is helpful.
Yeah.
Yeah, I've also found it always to be a helpful process.
That's great. So I guess one of the things I just sort of like to touch on just before we sort of wrap up, in case, and just sort of put a call out for any more questions. One of the things I like to stress with investigators is that once you've submitted that report, your role is done. We're very grateful for you. I will send you a letter to that effect, extending our thanks and gratitude. And we do share the investigation report with the respondent lawyer and the complainant so that they're aware. We also, if the conclusion is there is no reasonable prospect of conviction, we also take that report and provide it to one of the non-lawyer members of the discipline committee. And we have them review it and ask, to make sure that they agree with the outcome. Just so that there is a second set of eyes, non-lawyer perspective, that reviews this and that agrees ultimately with the conclusion when it's being dismissed. So that's sort of an extra level that's sort of done. But if after you've done your investigation, you continue to be contacted by the complainant, by the respondent lawyer, why did you decide this way, these kind of things, don't respond. Reach out to the Law Society, reach out to myself or the relevant vice chair, and we can follow up and close the loop with that person. That's not something that we're going to expect you to take on. Your role is finished with the report, and you shouldn't have to be justifying the conclusions that you reach with people. We will take care of that for you. So that's just one thing. I know often sometimes investigators want to know what happens next after they completed their report. But, at that point, your role is done, and whatever does happen next is either in the hands of the chair or vice chair, or ultimately onto a sole inquirer or committee of inquiry, at which point then you will know what has happened. But there are possibilities for mediated resolutions even at this point for the fireside chats, and that's just not something that we're going to close the loop with the investigator on. Once you've reached that conclusion, your role is done, and we go forward from there. Are there any other closing comments before I do a wrap up? I don't see any more questions so far. Rohan, any closing comments from you?
Nothing for me other than to mention that it's been helpful for me to just go through the process of preparing for and being in this CPD, to make me reflect on the experience I've had, and I think it'll benefit me for future investigations.
And Sheila?
Just to say that this is really serious work. Glenn, I don't think any one of us takes it lightly. It's a hard thing to be investigating somebody's conduct. There's not a lot of joy in it, but it's important that we do it well. And thank you for putting this on.
No problem. And a couple of key takeaways, I think, for members who are responding to a complaint, a couple of key takeaways is remembers the investigator is just doing their job. talk to another lawyer. Like Sheila said, you don't need to retain counsel or anything like that, but when you're working on your response, talk to another lawyer, talk to someone, you know, that you trust, just to sort of gauge your response. You know, they can sort of help you with that. In terms of the investigators, like once you're getting into that investigation, you know, I think really trust yourself and trust your process. I think what you've heard today is that there is no one way to approach an investigation. There's not even one way to approach writing your investigation. You know, everyone is going to work slightly differently. It's the same way that we all approach the practice of law slightly differently. How we form arguments, how we prepare for cases, how we prepare for deals. We all do that a little bit differently, and every investigation is going to be different. But if you stick to those key principles of, you know, being responsive, being timely, you know, making sure that the process is fair, whichever process you do use for your investigation, you have to make sure that it is a fair process. So like I said, while there may be differences, ensure that the process is fair. And if you have questions, reach out to the chair or the vice chairs. So myself as chair, Tracy Carroll is one of our vice chairs. Michelle Thureau is our other vice chair. So feel free to reach out to one of them as you're going through. And I would usually start with either whether the chair or the vice chair who sort of has brought you on as the investigator. Often we will have, like, for example, Tracy will take on a complaint in a matter where there might be a conflict for me. So then she would be the one getting you on board as an investigator and making all the decisions as the way along. So always start back with that, the chair or vice chair who has you working on the file, because like I said, there may be conflicts for the rest of us. I don't see any other questions. I want to thank Sheila and Rohan. It's been, you know, not, like I said, we often call on members to do the investigations and do that as a volunteer work. And then to go out to some of our experienced investigators and say, now we actually want you to volunteer to talk about how you do what you do, is always a challenge, but I appreciated that, in fact, they were both so willing to do it. And I'm hoping for those members who are on the discipline committee, this has provided some insight to you in terms of how you approach your investigation. And as I end all of these, if you qualify for membership of on the discipline committee and are not on it, please reach out to the Law Society and volunteer. The more members we have, the more the responsibility is shared, and the less often you'll be called upon as a volunteer. So please do consider that. Otherwise, thank you very much for joining. It was nice to see such a big turnout for this. And yes, this counts for your ethics hours.
Thanks, Glenn.
All right, thank you, everyone. Glenn, Tate, if you're still on there, is there anything else from the Law Society?
No, Glenn, there's not. You stole all the stuff that I was going to say. I just want to acknowledge again that the thankless work that the Discipline Committee does, and extend the Law Society's appreciation to you, to Sheila, to Rohan, to all the members of the Discipline Committee, and echo your plug. If there are people who are interested in serving on the committee, we're happy to hear from you. Thank you, everybody, for your participation. Enjoy the rest of your evening, rest of your afternoon. Bye now.